Jai Hind everyone. I am Vikas Roshan, Assistant Professor, AKGEC Ghaziabad. The subject is Constitution of India, Law and Engineering. Under this subject, I would discuss about one of the important topics, and that is Information Technology Act 2000, that is also known as IT Act 2000. So before I talk about introduction of this topic, I would tell you about the relevance of this topic. Nowadays, we are heavily dependent upon internet. We are facing so many cyber crimes these days. Today's newspapers are filled with lots of news of cyber crimes, and even you could have learnt about cyber frauds with your relatives, friends. So this is the new dimension of crime, and this is the era of information technology and communication. So in this growing era of internet, cyber crimes, and new modes of cyber thefts, we need to know about the protection system that is made in our country India, and that is in form of IT Act 2000. So it is relevant for us. If we Indians understand about this, we can safeguard our interest, we can protect us from any potential cyber threats. So now, talking about its introduction. The Information Technology Act 2000 was enacted by the Indian Parliament in 2000, and to be precise, it was made on 9 May 2000, and the contribution goes to our then Prime Minister, then IT Minister Pramod Mahajan. He, along with his team, made this act in order to make it feasible for we common people in terms of e-commerce, in terms of protecting ourselves from cybercrime. So it is a primary act of India that deals with cybercrime, that deals with cyber theft, that deals with facilitating e-business and e-commerce. This act was enacted to give legal sanction, legal authentication to electronic commerce and electronic transactions takes place in our country. Apart from that, it enables e-governance, and it also prevents from any potential cyber thefts, cybercrime. Under this law, for any crime involving a computer or a network located in India or even outside India, if foreign nationals are also involved, then this will come under the IT Act 2000. So the person who is engaged in cyber theft, cyber crime, if he is residing in India or outside India, will come under the purview of this Act, IT Act 2000. They can be penalized, they can be charged under this Act. The law prescribes penalties for various cyber crimes and fraud through digital and electronic format. Apart from that, this Act gives authentication to the advanced electronic signatures, that is electronic that authenticates electronic documents. Even it helps in electronic bidding for various government bidding. The IT Act also amended certain other provisions, since lots of laws were there in India, but because of arrival of IT Act 2000, some other pre-existing acts were also modified accordingly, like the Indian Penal Act IPC were amended, Bankers Book Evidence Act, thereafter the Indian Evidence Act 1872, Reserve Bank of India Act 1934, and apart from that some other acts were amended to make streamlining with IT Act. Government of India banned various Chinese application under this Information Technology Act. Indians were a fan of TikTok and other Chinese applications, but after seeing various aggressions from Chinese at Indian border, Indian government decided to apply this act on Chinese applications like TikTok. You could have also learned about that so if anyone is putting bad remark on some renowned figure or any person, he or she can be penalized. One case you can remember about Bala Thackeray, during the funeral of Bala Thackeray, one bad comment were passed and the culprit were nabbed. So, recently, you could have learned about that one morphed photo of UP CM Yogi were posted on social media, and thereafter the person was penalized. So, this is the role of IT Act. The IT Act safeguards the interest of Indians against any cyber crime, and it also facilitates e-commerce and e-business. Now, talking about some features from the various sections of this IT Act 2000. Since this act, there is a body of United Nations that is known as UNCITRAL, or popularly known as UNCITRAL. This is a commission, a body of United Nations, and it was made in 1966. This United Nations Citral body, actually the full form of this body is United Nations Commission Commissions on International Trade. So, this body, United Nations Commission on International Trade, this is an important body, and this facilitates foreign trades. It also eases export and import between two countries. So, actually, this body wanted many countries to follow the common law regarding IT fraud, regarding IT transformation, regarding e-commerce, and India accepted this as a 12th member. So, one of the founding member was India of this body. It has extraterritorial jurisdiction, means IT Act is applicable even outside the India as well if the crime is attached from outside India. It defines various terminologies used in the Act like cyber cafe, computer systems, digital signatures, electronic records, data asymmetric crypto systems, etc. And that is defined in section 2.1. Thereafter, this IT Act protects all the transactions and contracts made through electronic means and says that all such contracts are valid as per the section 10A of this Act. It also gives recognition to digital signatures and provides method of authenticating these digital signatures for various electronic biddings and other purposes. It contains provisions related to the appointment of the controller and its power. Thereafter, it recognizes foreign certifying authorities as per the section 19 of this IT Act 2000. Some other features. It also provides various penalties in case of computer system is damaged by someone other than the owner of the system. If owner like you destroys your computer, it is not a crime because it's your property. But someone else damages your computer through various by putting virus in your computer or by other fraudulent means, then the person will come into the net of this IT Act. This Act also provides provisions for an appellate tribunal, cyber appellate tribunal to be established under this Act. All the appeals from the decisions of the controller or other adjudicating officers lie to the appellate tribunal. However, the cases coming to this appellate tribunal, if the aggrieved party is not satisfied, he has a final, he can approach to high courts as well for rehearing of the cases. The Act describes various offences related to data and defines their punishment. We will discuss in coming slides that what all sections are there in IT Act and under what circumstances, under what conditions, what type of punishment can be awarded. So, it also provides circumstances, conditions, situations where the intermediaries, where the middlemen are not held liable, not held responsible, even if privacy of data is breached. If the privacy of data is breached and there is no involvement of middlemen, he can be spared. A cyber regulation advisory committee is set up under the Act to advise the central government in all the matters related to e-commerce and digital signatures. So this is also an important provision of this IT Act 2000. Now, these are some basic features of this IT Act. Now, what is the objective of this Information Technology Act 2000? Means, what is the purpose of making of this IT Act? The simple thing is this, that if this act was not in place, no doubt we Indians could have faced lots of difficulties in order to protect ourselves from cyber crimes, from cyber threats, cyber bullying, and other cyber challenges that is increasing by every passing day, in fact. Some other objectives of Information Technology Act I am discussing. So the act is mainly passed to deal with e-commerce and regarding digital signature and to deal with cyber threat. It also regulates and protects sensitive data stored by social media like WhatsApp, like Facebook, like Insta. So many social media is there where you put your photographs, your sensitive information you share with various sites. So what if there is no act to safeguard your data, then your privacy, your security could be challenged, could be compromised. So it regulates and protects the sensitive data stored by social media and other electronic intermediaries. Sometimes you put your data on Flipkart, on Amazon, on various portals, on various social media. If such acts are not in place, how can you approach the body to ask for damage compensation, for ask for the fraud that took place with you? Because sometimes these days you may have seen that under sales, if you are asking for a mobile, if you have ordered a mobile, you could have got a brick in place of mobile. What could you do? You have the only solution to go through the act of IT Act and take the damage compensation as per this act. The act seeks to protect all transactions done through electronic means via mobile wallet or through payment systems, other sites, through banking website as well. E-commerce has reduced paperwork used for communication purposes. Through e-commerce, we see that lots of paperwork is reduced and some toughest work can be done with the twinkling of an eye. It also gives legal protection to communication and the exchange of information through electronic means. Legal protection is awarded in this IT Act. It protects the digital signature that is used for any sort of legal authentication. Digital signature is the requirement of the new and vibrant India, where the digital India is faster than the traditional India, and in this scenario, the role of digital signature, e-signatures are rising day by day. It regulates the activities of intermediaries by keeping a check on their powers. Indian government is very keen to take care of data. Even the government is forcing various mobile companies to keep the server of the data in India itself, because it was found that in past many companies were keeping the data of Indians in places maybe in China or in other places. It defines various offences related to data privacy of citizens and hence protects their data. It provides recognition to books of accounts kept in the electronic form regulated by Reserve Bank of India Act 1934. Now there is no use of keeping heavy books and larger books of accounts. You can keep them simply in electronic form. You can store it at very smaller place, but the authentication of this data can be provided by this Act IT Act 2000. Now coming ahead, Schedule of Information Technology Act 2000. The Act is divided into 13 chapters, 90 sections and 2 schedules. Earlier there were around 94 sections and 4 schedules were there, but later on the sections were reduced to 90 sections and schedules were reduced to 2 schedules. 2 schedules are omitted. So we see that the whole Information Technology Act is divided into 13 chapters, into 2 schedules, and thereafter 90 sections. So now let me explain briefly that what all contents are there in all chapter. Chapter 1 deals with applicability of the act and definition of various terminologies. In chapter 1 we will know about the application of this act wherever it is applicable, where it and various terminologies related to IT. Chapter 2 talks about the digital and electronic signatures. Various types of signatures are there, level 1, level 2, level 3. Chapter 3 and 4 talks about electronic governance and electronic records respectively. Means electronic governance is explained in chapter 3, while regarding electronic records matters are kept in chapter 4. Chapter 5 is related with the security of data. Then comes chapter 6 that deals with regulation of certifying authorities. Further, chapter 7 talks about certificates that is required to issue an electronic signature. Thereafter, chapter 8 gives duties of the subscriber. Who are subscribers? I and you are the subscriber of any services. So what is the duties? What are the duties of we subscribers? While chapter 9 describes various penalties, what I will discuss in coming slides. Chapter 10 provides sections that is related to appellate tribunal, cyber appellate tribunal. Chapter 11 describes various offences related to breach of data and their punishments. Then comes chapter 12 and it provides the circumstances, conditions, situations where the intermediaries are not liable to any offence, cannot be held guilty. The final chapter, chapter 13 of IT Act 2000, talks about various other miscellaneous items, topics, things. And since we know that this act is divided into 2 schedules, and the first schedule talks about the documents and the data where act is not applicable, while schedule 2 deals with the electronic signatures and its method of authentication. So I have given you the brief idea that what all things are covered in this IT Act, under what chapter, what things will be explained. Now the most and crucial part of this IT Act means, and this is the regarding the offences and punishment as per the IT Act. So now I will tell you that if any particular cyber crime is done, what all sections, what all punishments are there as per the various sections of IT Act. Starting with section 65. Section 65 talks about tampering with the documents stored in a computer system, and the penalty for this this act is imprisonment of 3 years or a fine of 2 lakhs, or both can be awarded. Section 66 of IT Act 2000 talks about the offences related to computers or any act mentioned in section 43. Section 43 covers lots of acts. If the crime, the act falls under this category, that is under section 66, then the penalty could be imprisonment of 3 years or the fine that could lead up to 5 lakhs, or both can be awarded. Coming to section 66B, and under section 66B of IT Act, receiving a stolen computer, source or device dishonestly can land you in imprisonment of 3 years or fine up to 1 lakh, or both can be awarded. Now coming to section 66C, this is regarding theft of identity of a person, theft of someone's identity, and for this crime the punishment is imprisonment of 3 years or a fine up to 1 lakh, or both. Now, section 66D, and this is regarding the cheating by personation. And for cheating by personation, the penalty would be imprisonment of 3 years or a fine up to 1 lakh, or both can be awarded. Now see other sections, other acts, cyber crimes and its penalties. So under section 66E, that deals with violation of privacy of a person, and in this situation the penalty could be either imprisonment of 3 years or a fine of 2 lakhs, or both. Section 66F, and this is regarding most dangerous act, that is cyber terrorism. And for this you can imagine that a toughest punishment could be given, and this could not be only just 3 years or 1 lakh rupee fine, it would lend to life imprisonment. And in some cases, if it is thought that the cyber terrorism is beyond the limit of this, and the person in question is more dangerous, then some other tough penalties could be awarded to the person. Section 67 deals with transmitting obscene material in electronic form. We more often see on WhatsApp group some bad and obscene scenes are circulated, sometimes of a political leader, sometimes of a popular personality, celebrity, or sometimes of some friend or something, morphed photographs. If such things are happening, this is a cyber crime, and the aggrieved party can take assistance as per the IT Act, and can get the culprit can get the culprit imprisonment of 7 years and fine up to 10 lakhs. We see that the nature is severe, and that's why punishment imprisonment is extended to 7 years in place of 3 years in other simple crimes, and the fine of 10 lakhs is also there. Means there is no option, this is end, both will be awarded in this situation. Now the situation is that in case of depicting children in sexually explicit form and transmitting such material through electronic mode, we know that the children are our future, and if they are dragged in pornography or in act like deterioration of their image, some obscene scenes are made involving children's, then you can imagine that the level, the character and of the culture will automatically go down. So for this, very strict provisions are made, and in case if any children is engaged in any video or in any photograph, then the imprisonment of 7 years and a fine of 10 lakh can be given, can be no, it must be given if it is found. Now coming to one more condition, failure to preserve and retain the information by intermediaries. If intermediaries of e-commerce fail to retain information, then this is also a case of negligence, and in this case of negligence, the punishment imprisonment of 3 years and a fine, suitable fine, will be awarded. So I discussed some common offences, and under article of various articles of IT Act 2000, various imprisonments are also there. So we went through this. Now about the limitations of this act. This IT Act is very strong, but still it is having some limitations. It is not purely proof. You can say that it doesn't have any leak. So many problems are there. Since the cybercrime cannot be defined easily, because by every passing day, new and new cases of cybercrimes are coming to us. And in this scenario, what punishment you make today could, sometimes it may happen that new cases are coming that is not dealt in earlier IT Act. So new and new types of crimes are coming by every passing day. In this situation, we see that there's a limitation of IT Act. This is This is something that new dimensions of these crimes are increasing. So we obviously observe a limitation of this IT Act. Means we have made so many provisions, but still when we talk about ground reality, many things is missing. So I have mentioned some basic limitations of this IT Act 2000. No provision for breach of data. In case breach of data of a person like me and you is done, so there is no provision at least. So the provisions of the act only talk about the gathering the information and data of citizens and its dissemination. It doesn't provide any remedy for the breach and the leak of data, nor does it mention responsibility or accountability of the government officials or the body that is engaged in the breach of data. So this is one limitation, that for breach of data, strong provisions should be made. No address to privacy issue. The act failed to address the privacy issue of an individual. The intermediary could store any sensitive information and can provide to the government at the time it is asked for. But you know, your private data is shared, no matter whether it is shared with the government, no matter it is shared with any responsible body. But one thing is sure, that your right to privacy is compromised. Simple punishments are there. You know, if punishment is tough, it will discourage many other people to replicate such crimes. So it is recommended by many IT professionals, many IT scholars, that there should be toughness in the penalties, in the punishment of this IT Act. So this Act describes certain offences committed through electronic means. It is very simple in nature. The punishment should be tougher one, rigorous one. Lack of trained officers. The persons sitting in police stations are not trained to deal with the cyber crimes, to understand the laws, the frauds that can take place under the IT. So experts should be there so that they can understand the problem of common people. And one more problem, India is a country of 1.4 billion people, 140 crores people are residing in our country. So such a huge population, and we know that less police stations are there, and apart from that, these police officials are not trained to address these IT issues. So proper training is required, and some trained officers should be there to deal with the cyber crimes. No regulation over cyber crimes. With the advancement of technology, cyber crimes are increasing at a greater pace. The offences described in the Act are limited, while the other hand, various types of cyber crimes are already prevailing, which is not addressed properly. So, as the time will progress, new and new ways of cyber crime will surface. So, it need to be regularly updated to address all the situations of cyber crimes. So I hope that this video would help to understand the basic theme of IT Act, how it can protect us, the penalties provided under this IT Act. So thanks a lot. Thank you all.